Bismillahirrahmanirrahim. So, in the previous two classes, we have discussed about the mediation, arbitration, and the ADR mechanism. So, first of all, I have to mention the ADR. ADR is one kind of alternative dispute resolution. That means a person can go outside the court and he can make a very good result and best interest of the suit or a dispute by the ADR mechanism. So, before 1980s or 1990s, the people had no idea about the ADR mechanism, more focusing the arbitration, more focusing the plea bargaining, more focusing the mediation also. So this is the time to talk about this matter. So right now I would like to discuss about the arbitration and the effect of arbitration. Arbitration means it's on kind of ADR procedure or the mechanism where the parties can establish his rights, his activities, even his demand by negotiation. So negotiation is a very good effect over the arbitration process or mechanism. In the village area, we have seen lots of incident of the arbitration, but arbitration it is not easy as like the village procedure or the village mechanism. Though it is not the judicial system, it is on kind of quasi-judicial system, whether the judge will follow some of the time the judicial interpretation, some of the time the non-judicial interpretation. The core object of arbitration is that to resolve the matter, to resolve the dispute, to resolve any settlement with a very short time, with a very short money. You know that if you have a intention to go to the court for the court trial or the court procedure, it takes too much time, and this is actually important for our common legal system because 90% of our people they are poor. So for them to continue a legal proceedings, it's actually a hard task. So for these reasons, arbitration can be a very good mechanism. But if I talk about the Arbitration Act 2000 on, there are some of the regularization. That means the Arbitration Act 2000 on only deals with the business related activities or the commercial related activities. So Arbitration Act 2000 on is on kind of very good laws for the perspective of Bangladesh. So right now we can analyze about the importance of the Arbitration Act 2000 on. The basic important of the Arbitration Act 2000 on is that by the 2000 on Act, Bangladeshi government has changed the legal practice and practitioner procedure of the Arbitration Act. Before 2000 on, there was also exist of arbitration in Bangladesh, but in that time, in that mechanism, they did not follow the natural justice, they did not follow the generalized category of the justice. So whenever the Arbitration Act 2000 on is established, in that time they have also discussed about the many types of legal and the social interpretation, and in their section 2 they have clarified every definition, every pros and every concerns related to the Arbitration Act 2000 on. The second principle of Arbitration Act 2000 on is that Bangladesh is a developing country. Even Bangladesh has huge amount of emerging industry. Whenever industry would like to make a contract with another country, in that time there seems there can be produce some of the dispute. So if the party fail these types of dispute settlement to the foreign party, how they will deal with this matter? Definitely they will deal with this matter through the Arbitration Act 2000 on. The third reason of Arbitration Act is important is that Arbitration Act result or arbitral tribunal result is actually binding and final. So whenever a result is binding and final, there are no types of implementation of appeal, review and revision. And you know that appeal, review and revision, it takes too much time from the judges, from the advocates and from the court procedures. Even the people's justice has been tolerated, has been violated by the justification of these types of appeal, review and revision. In that mechanism, in that process, the Arbitration Act 2000 on, it is on kind of best laws, and actually it is on kind of quasi-judicial system. Though it is mentioned that in the Arbitration Act 2000 on, it will deal with the arbitration tribunal, but who will be the arbitrator? Who will be the arbitrator tribunals? Main fact or main people, actually the judge of district judge, the district judge court, any judge from the district judge court, he will be the arbitrator according to the Arbitration Act 2000 on. But if the party they are not interested with these people, they can also include another two judges for the interpretation in the national arbitration and the international arbitration. So it has actually a great issue over the Arbitration Act. But before making an arbitration tribunal's judgment or before making an arbitration tribunal's result, you have to remind that there must be an arbitration agreement with the both parties. Whenever, for the very beginning, the arbitrator tribunal is going to make a very good justification, he have to see that there is a very good agreement. So what do you mean by the arbitration agreement? Before doing any kind of agreement, before doing any kind of contract, the both party, the plaintiff and the defendant, they already made a contract, and this contract will be known as the arbitration agreement. And you have to remind that without a arbitration agreement, there will be no types of single arbitration. For making a very good judgment, for making a very good arbitral award, there must need the arbitration agreement. So according to section 43, we have already mentioned the arbitration tribunal's result is final. But if there any kind of irregularity on the basis of arbitration agreement, that means if there were no types of arbitration agreement in the arbitration tribunal, the court will falsificate, the court will declare invalidate of the arbitration award. This is on kind of set aside by the High Court division cases. So what is the core duty of the arbitration tribunal? Actually, the arbitration tribunal is on kind of court. So the arbitration court will do its activities on the basis of our formal legal system and the legal jurisprudence. Whenever they will give any kind of verdict, they will follow our code of civil procedure, because this is on kind of civil suit, and code of civil procedure is the finest code related to make a very good decisions for the civil suit factor and the civil suit decisions. Besides, they will also follow the Limitation Act, they will also follow the Evidence Act, even they will also follow the civil judicial related activities. That is much more important to make a very good rational judgment over the Arbitration Act 2000 on. But the good advantage of the arbitration tribunal activities is that the arbitration tribunal activity will follow the natural justice. The arbitrator will give the opportunity to the both parties, as the both parties can produce his saying, can produce his evidence, can produce his authentic documents. But in that mechanism, after hearing the both parties, the arbitral tribunal will not give any kind of verdict. The arbitral tribunal will see all the facts, all the circumstances, all the documents on the basis of the parties' demand. Whenever the arbitral tribunal is satisfying that all kinds of documents, all kinds of legal matters, and all kinds of legal evidence is true and it is consistent related to the Arbitration Act 2000 on, in that time the party will be going through the process of the arbitral award. Actually, the arbitral award is related to the judgment. And you know that in the last stage of a court procedure, in the last stage of the trial stage, the court is actually giving the judgment. The court is actually providing the judgment on the basis of the evidence and documents. So this is the last activities of the arbitrator, to see all the facts, all the circumstances, all the evidence with the best interest for the parties' circumstance. Whenever the arbitrator will satisfy on that material effect and circumstance, in that time the arbitrator will give a very good settlement, and the settlement is final, and the settlement is free from any kind of inconsistency. But there are some of the grounds, on the basis of the grounds the court may invalidate or set aside the arbitrator or arbitration tribunal. The first reason is that whenever the arbitrator or arbitrator activities is not following our national principle, In that mechanism, the High Court division has the right to declare inconsistent, to invalidate the arbitral award from the court proceedings. The second reason is that whenever the arbitrator tribunal did not take the advantage of providing notice to the both parties, in that mechanism, the High Court division may falsificate, the High Court division may declare inconsistency of the arbitral tribunal's report, and this is actually on kind of verdict on the basis of the social interpretation, judicial conscience of the High Court division, and actually the court will follow these circumstances for the ends of justice, because you know that there are no types of single procedure of the appeal, review and revision, but this is on kind of good opportunity given by the High Court division to set aside the cell. One of the basic reason of the set aside is that the arbitral award deals with the dispute not contemplated by or not failing with the terms of submission of arbitration. That means whenever the circumstances is not included in the paper of the arbitration agreement for the very beginning of the commencement of the contract. So in that mechanism, if the arbitrator, if they took any kind of proceedings which were not mentioned in the arbitration agreement, this will be called nullified, this will be called void by the High Court division. So this is on kind of fact and circumstances related to the Arbitration Act 2000 on. But there are some of the basic principles and disadvantages of the laws also. You know that every laws have some disadvantage and limitation actually. So the basic limitation of the Arbitration Act 2000 on is that you will only deal with this matter related to the business related activities and the civil dispute related activities which is mentioned by the arbitration agreement. But you know that there are lots of civil proceedings, but all types of civil proceedings will not be regulated by the Arbitration Act 2000 on. This is the biggest limitation of the Arbitration Act 2000 on. The second vision is that actually the object of arbitration is that to make a very good settlement on the basis of the impartiality, on the basis of the fair means, but there are mere possibility to make the injustice by the judges in the arbitration mechanism, but there are actually absence of appeal, review and revision. Literally, appeal, review and revision is on kind of basic weapon to provide a very good judgment for the ends of justice. So whenever the appeal, review and revision procedure is absent in an act, that means this is not a very good act. The judge can make wrong. It is on kind of basic idea. Every people can make wrong. There is a proverb of English law is that to err is human. But the Arbitration Act 2000 on believe that there will be no types of single implementation of the appeal, review and revision. So this is on kind of biggest disadvantage of the Arbitration Act 2000 on. The third disadvantage of the Arbitration Act is that though it is said that ADR is a very good mechanism to make a very good judgment, to make a very good justice with a very short time and with a very short money, but these types of arbitration mechanism and arbitration agreement, it is not for the poor people. Only the rich people, the business magnate, the social stakeholders will connect on the matters, because not more than 1 crore, 2 crore, 50 crore takas case is dealing in the arbitration agreement to, or Arbitration Act 2000 on. No single or civil matters which is petty offenses, it will never deal with the Arbitration Act 2000 on. This is on kind of big limitation of the Arbitration Act. The fourth limitation of the Arbitration Act is that the judges are not expert in the circumstances. In the court procedure, in the civil procedure or the criminal justice procedure, the judge actually claiming the help from the amicus curiae or the friends of the court. But during the time of arbitration agreement or arbitral tribunal, the judge is the sole stakeholder to provide the judgment. Whenever you will giving your power to give the judgment to the sole arbitrator, there are mere possibility of the injustice. So actually this law is made for the justice, but by the procedure, by the technical difficulties, there are mere possibilities of remaining injustice by the Arbitration Act 2000 on. So this is on kind of biggest limitation of the Arbitration Act 2000 on. So in these cases, I have some recommendation. If the government is following these types of recommendation for the ends of justice, the government can include this matter in the Arbitration Act 2000 on. The first recommendation is that the government can remove the difficulties from the losses. The government can make the liberal definition of section 2 mentioned in Arbitration Act 2000 on. Whenever the definition will be liberal, whenever the judge can make a liberal decision on the basis of his judicial conscience and the judicial justice, there will actually no problem to make a very good judgment. The second problem of the second recommendation, the judge have to expert. So this is the duty of the government to make the expert of the justices or the judges. So whenever the judge will get some authentic information, authentic workshop on the basis of the arbitration mechanism, in that time he will make a very good judgment with a very short time, with a very short proceedings. So regardless of hundreds of barrier, I believe that Arbitration Act 2000 on is on kind of basic laws which has an intention to provide a very good judgment to the common people. Actually, these are not the common people, they are the rich people who are dealt by the Arbitration Act 2000 on. The third recommendation of the Arbitration Act is that this law has been made in the year 2000 on, and this is the time of 2026. Our whole world is updated. Why it will not make a very good effect over the laws? So this is the time to make a very good recommendation over the fact, over the circumstances, even over the procedure of the Arbitration Act 2000 Act. If the government make any kind of recommendation of the Arbitration Act 2000 on, it would be a very good decision for the judges, for the advocates, and for the generals also. I have some recommendation to the advocate also. Even 90% of the advocate, they have no idea about the Arbitration Act 2000 on. But this is one kind of glaring example of a very good laws in Bangladesh. So after 2008, this is some kind of finest law. But our advocate, they are not cope up with this matter of the Arbitration Act 2000 on. So to make a very good issues over the factor of the arbitration tribunal or the arbitration agreement, definitely the advocate should gain some of the knowledge over the Arbitration Act 2000 on. The last recommendation is that the government's duty is to make the public education or the legal education over the Arbitration Act and include the all kinds of petty offenses related to the civil matters. This would be a very good loss for the future time. So I believe that in the future time the government will include all kinds of matters and satisfactory element for the ends of justice and for make a very good judgmental issues over the Arbitration Act 2000 on. Thank you.